Good day, Crime Talk aficionados. That's right, it is Sunday, and we have the weekly recap, a weekly recap of all the top stories throughout the week of December 2nd, 2024. They have been put together in one convenient location, all the top stories throughout the week, conveniently located in one location right here. Thanks for watching. We'll see you next time.
All right, lawyer.
Next in the docket, Jennifer Crumbley. I think she may be right. And boy, did I take a lot of flack for this case, but it looks like somebody else agrees with me. So 10 months after being found guilty of involuntary manslaughter, Jennifer Crumbley, the mother of the Oxford High School shooter, has asked a judge to throw out her historic conviction, alleging that she was the target of an overreaching prosecution that made numerous missteps, including deliberately withholding evidence from her about secret deals it made with school witnesses who testified against her. Now, those deals were first disclosed by the press when a newspaper learned that the two school officials who drew scrutiny over their decision involving the shooter had signed a confidential proffer agreement that protected them from having anything they told investigators used against them. Now, those agreements, however, were never made known to the defendant or the jury, which Jennifer Crumbley's appellate lawyers argue in a new court filing was completely unlawful, and I agree. Specifically, the attorney alleges that the school witnesses were hoping to avoid prosecution over their own acts and therefore had a motive to testify in a way so as to shift responsibility towards Mrs. Crumbley and away from themselves. Oh, a motive to fabricate, you say? Oh, how interesting. Not disclosed to the defense? How could that not be turned over in any possible way? And if this, obviously they weren't turned over, but those district attorneys that handled this matter, I would get myself some counsel for the attorney regulation matter. Unbelievable. So anyway, the jury never got to hear that because Crumbley's new lawyer maintains that the prosecution ensured the defense that they were never going to be privy to it. Anyway, these proceedings were tainted from top to bottom and were born out of prosecutorial overreach, attempting to criminalize non-criminal conduct. The appellate attorney, Mr. Michael Desi, writes in a pleading, maintaining that there were no legal grounds to charge Crumbley to begin with. Apart from improper decision to charge, Ms. Crumbley was denied a right to a fair trial, where the prosecution deliberately withheld evidence from the defense, key impeachment evidence as it relates to the proceedings, and a completely inconsistent legal theory that is a grave injustice to the law. Attorney for Ms. Crumbley, Mr. Desi, maintains that the prosecution wrongfully asserted two contradictory theories by charging the shooter as an adult, but at the same time alleging the mother failed to control her minor child, the one who actually pulled the trigger and claimed the lives of Hannah St. Juliana, Tate Miri, Madison Baldwin, Justin Schilling, and 6 other students and 1 teacher who were injured. Now, Desi argues it's inconsistent to portray the shooter as an adult in his prosecution, but then paint him as a minor child in the mother's case. Now, the prosecution can't have it both ways, they argue. Maintaining a parent's legal duty to control their child typically involves young children who aren't aware of the dangers or harm they are causing, not to teenagers like Ethan Crumbley, who methodically planned the November 30th, 2021 high school massacre in his journal, writing that he hoped to kill as many people as he could and deliberately chose to surrender so he could witness the suffering. Desi also cites an investigative report that concluded former Oxford High School counselor Sean Hopkins and former dean of students Nicholas Ajak made crucial mistakes on the day of the shooting. There were 2 school officials who signed confidential agreements early on with the prosecutor's office, as it built a historic case against the Crumbleys in this particular case. He argues their mistakes include letting the shooter return to class despite receiving multiple warnings about his behavior hours before the shooting, not searching his backpack, which contained the gun, and not requiring his parents to bring him home after discovering a violent drawing he made of the gun, a human body bleeding, along with the words, "The thoughts won't stop, help me." Now, the point of the highlights of these investigators' findings is not to prove the criminal responsibility of Hopkins and Ajak. Rather, these findings merely demonstrate why Hopkins and Ajak were given proffer agreements in the first place, because they had obvious criminal exposure, attorney writes in his briefs. Now, Desi, the attorney, submitted the filings with the help of law students from the University of Detroit Mercy School of Law, which assisted him in taking the first formal step to have Jennifer Crumbley's conviction thrown out. Jennifer Crumbley's convictions for involuntary manslaughter stem from a trial riddled with legal errors where key evidence was withheld and cooperating agreements were peddled and suppressed to secure testimony for the prosecution to convict an individual who committed no crime. Now, Desi said in a statement on Monday, adding that he outlined several legal errors that cast serious doubts as to the legitimacy of this sham prosecution. Now, who was the other guy that thought this was a complete overreach and be careful what you wish for when they start using unique, novel legal theories in which to go after people for the responsibilities of their children? Yeah, I think it was this guy. That's right, this guy right here. Anyway, there's a reason why no parent in America has ever been held responsible for the criminal acts of their child in relation to a school shooting. It is because Mrs. Crumbley committed no crime. The case should be concerning for parents everywhere. Now, the prosecution allegedly failed to turn over exculpatory evidence or evidence that is favorable to the defendant by not disclosing they had entered into this proffer agreement with two key school officials, by not offering these agreements and recorded interview statements to the defense. The prosecution allegedly asserted inconsistent culpable theories by charging the shooter as an adult. He was also sentenced as an adult while at the same time claiming the mom failed to control their minor child. Under common law, Jennifer Crumbley allegedly owed no legal duty to the victims of the shooting, no more than someone has a duty to act if they see someone robbing a store. Now, their argument argues that this case should never have been charged in the first place, and the prosecution cannot prove that the mother had a duty to protect the student's victims from her son because he maintains no such legal duty exists in Michigan or elsewhere. The prosecution's claim that she does is an issue for the civil courts, not the criminal courts. Now, the court's jury instructions allegedly were flawed as well, in that the judge erroneously instructed jurors that they could convict Jennifer Crumbley without unanimously agreeing to what crimes she committed. The jurors were allowed to convict under one of two theories, by concluding that she failed in her duty to control her minor son, or that she failed to properly secure the gun and consequently gave him access to the gun. The jurors were told they didn't have to all agree on which theory they were to convict under the law, and that's flawed. Maintaining if 6 jurors concluded it was a gun theory and the other 6 went for the failure to control, that would be a hung jury. Anyway, Jennifer Crumbley allegedly had ineffective lawyers at trial as well. Gee, I don't know, ladies and gentlemen. My gosh, 10 months later, I mean, this case when it got charged, these are the exact same arguments that I was making. Now, you have to remember, at the trial court level, the trial court judges, they live in the community, right? They get reelected in that community. They want to keep their jobs. Yes, this whole issue went up to the state Supreme Court, and the court said, well, let's go ahead and go forward with it. But once again, you know, it's the heat of the motion, it's the heat of the battle, the emotion in the courtroom. Judges want to move cases along. They don't want to, you have sobbing victims crying in the courtroom. And, when you go to the appellate level, you get a little more, what's the word I'm looking for? You get a little more serious about the legal implications of what's actually taken place when you remove the emotion of the courtroom. That's why the appellate courts look at stuff on that cold, dark paper. That's all it is, right? Lawyers are supposed to make decisions with neither passion nor prejudice. I said all along, and I took a lot of beating from you all, I get it. This unique novel theory, my God, the Crumbleys, under this theory, every kid that's ever arrested or charged anywhere, the parents should be charged anywhere. So if you have young children, teenagers, heck, and in today's world where the kids stick around to like 26 or something living in your basement, hey, who's to say they're not children, right? It's scary, ladies and gentlemen, and I get it. It sucks. People want something to happen. Do something. So the prosecutors go and do something that they've never done before. and then it sticks, and they're going to start using it again and again and again. And we've seen this throughout the country. It doesn't take you long. Go down to Georgia for that school shooting. Once again, dad didn't say, let's go shoot up the school. If that were the case, I'd say they're guilty. But if being a bad parent, maybe being a little scatterbrained, maybe being busy with work is a crime, look out, because anyone in America could be charged for that case. And where does it stop there? Just at crime? How about just other civil? It just never ends, ladies and gentlemen. I know people are going to say, Scott, but there's 4 dead people. It was a school shooting. I get it. It's tragic. And you charge the kid that did it. He'll never get out of prison. But you don't charge the parents for that unless they said, hey, little Johnny, do you have your gun to go to school today? Yes, then they would be guilty. But if they didn't know about it, how could you be complicit in it if you didn't know about it? And then it also gets into that whole negligence standard. Negligence is for civil matters. Is it reasonably foreseeable? We don't normally charge people with a negligent standard of care in criminal cases. It's knowing intentionally, that type of situation. We'll see what happens. I believe it'll have to go higher through the appellate courts to be resolved. We'll see. Interesting. I think I'm right. A lot of people think I'm wrong. I guess we'll just have to wait and see. I'm not always right. Well, a lot of the time I am, but not every time. I'm not claiming to be right. I think it's like 98.6% of the time. Next on the docket, Sarah Boone. That's right. She had her sentencing today. And oh, what a painful sentencing this was. Okay. Now, Sarah Boone was convicted of murdering her boyfriend by suffocating him in the suitcase. And like I said, she was sentenced today in Orange County, Florida. Just a little background before we get to my discussion of the sentencing, which was painful. But back on October 25th, a jury took about an hour and a half deliberating in the murder trial of Sarah Boone, also referred to as the suitcase murder. Now, Boone was found guilty of leaving her boyfriend to die zipped up inside a suitcase for about 11 hours inside of their Winter Park home. Now, the medical examiner testified that Jorge Torres died from suffocation. His family declined to comment after the verdict, but they were heard today. Anyway, Miss Boone's defense attorney described Sarah Boone as shocked and disappointed. Just shock. She's shocked. She felt like, she had a defense. So this whole jury verdict came as a big shock to her. I don't know why she didn't have a legitimate defense. Anyway, during the trial, Boone took the stand in her own defense, describing how her 103-pound boyfriend got into the suitcase in their little game of hide and seek. She said, I zipped him up, thought it was funny. We're joking about how he was small enough to fit inside the suitcase. Just joshing around. Anyway, Boone told the jury how Torres threatened her, and the defense introduced photos of how Torres had injured her during their 3.5-year relationship. Psychologists took the stand to back up the battered spouse syndrome defense, which failed miserably, probably because the state's experts said Boone's behavior was not indicative of a battered spouse syndrome. In the end, the prosecution said the guilty verdict brought some closure for the Torres family. And after 4.5 years, the number of delays, I think they were finally happy to see the case finally go to trial and put this one in the book. Now, Boone requested a new trial, claiming she was wrongfully denied a court-appointed attorney. She also said the emotional outburst in the court by the victim's family should have caused a mistrial. Denied. All right? So obviously understand, at a sentencing, the victim's family gets to talk and say what a great guy the boyfriend was. I get it. I'm okay with that. They've waited this time. They get to speak their piece. But the defense attorney for Ms. Boone, oh my God, sit down, shut up, and say, Your Honor, there will be an appeal, and therefore I have instructed Ms. Boone not to say anything further. So bring it on. But no, not only did this attorney put Ms. Boone on to make a sentencing statement today and basically say, well, you didn't know the whole story, and then on top of that, basically gets up and tries to relitigate the case to the judge. We provided you video of the entire sentencing. If you'd like to watch it, you can. It's about 2 hours long. statements by everybody, hour and 55 minutes. Statement by the judge, less than 5 minutes. And what did he give Miss Sarah Boone? Life. Although she was given 4 years, 9 months, and 8 days credit. I hope this is the last we hear of Miss Boone. Somehow I don't think it will be. She will be claiming that she's been wronged and harmed for the rest of her days in custody. It took 4.5 years to get to this point. She is borderline delusional if she thought that she had a battered spouse syndrome. And that's probably why the 8 previous attorneys said, you're going to lose, and to take the deal. But clearly, Miss Boone knows better. She is smarter than everybody else. Next, a CEO is assassinated. I think that's the best way to describe it. Take a look at this surveillance footage obtained just moments before the United Healthcare CEO, Brian Thompson, was shot dead outside of a Manhattan Hilton hotel. Now, Mr. Thompson was seen leaving the hotel about 6:45 a.m. this morning, Wednesday, when a masked assailant draws out a gun with a silencer and shoots him in the back. Now, let's face it, this is New York City, ladies and gentlemen. I thought handguns were illegal. I certainly know you're not going to get a silencer in New York City. This seems like a professional job. Anyway, so Thompson, who's the head of the largest healthcare insurance company in the United States, stumbled away from the attacker. The gunman follows him and continues firing into the CEO as he hit the ground. The assassin then fled the scene and escaped into Central Park on a bike, with the New York Police Department releasing images of the assassin to aid in the search, and there's now a $10,000 reward. Now, witnesses said the suspected gunman was seen waiting for some time outside a hotel before the shooting and knew which door the Thompson was probably going to come out of and then open fire on him. Now, several people were seen in the footage standing nearby when Thompson was hit, with one woman sprinting down the street after being just a few feet away from the shooting. Now, Mr. Thompson was named the United Healthcare CEO back in 2021 and earned a reported $10 million. And for several years prior to that, ran the Medicare business within United Healthcare. He was slated to speak at an investor meeting at the Hilton Hotel soon after the shooting, and according to a release from United Healthcare, he was going to announce that the company's, was quite profitable for 2025, and they expected revenue to reach $450 billion. Now, the suspect remains at large and is described as a white male wearing a cream-colored jacket, black face mask, black and white sneakers, and a gray backpack. Now, people have also reported that the Thompson, who lives in Minnesota with his wife and children, was not a guest at the hotel but had arrived early to prepare for the presentation. Now, the gunman apparently knew the door that he was going to come out of before he shot him and then fled on the bike, like I mentioned. Now, according to Mr. Thompson's wife, a lady by the name of Paulette, she states that her husband had been receiving threats before his trip to New York, but she wasn't able to elaborate as to what those threats were about. Now, the DOJ did also open a criminal investigation looking at the company, but, those aren't going to go anywhere. Those are just kind of billing things to keep the government busy, and then the defense attorneys get to charge and they reach a settlement or something of some kind. But seems like a professional hit. Gonna see how this one shakes out, ladies and gentlemen. This could be very, very interesting. Next on the docket, Lori Vallow is going ProSe. Now, I'm not gonna lie, I want to watch every second of this train wreck, ladies and gentlemen, every second of it. So let's get you the news. One day after a judge declared Lori Vallow competent to stand trial, a second judge has now granted her request to represent herself at her upcoming murder trial in Arizona. Vallow returned to court today, and the judge, having found to be competent by 2 doctors who evaluated her. At that hearing, the judge based his decision to declare Vallow competent on the written reports by the doctors who met with Ms. Vallow on November 7th, as well as on December 2nd of this year. Now, the judge found Ms. Vallow understands the proceedings and will be able to assist in her defense. However, Vallow was not interested in assisting her attorneys in the defense of her case and asked to renew her request to represent herself. The judge reminded Ms. Vallow that it's very risky to represent herself, noting that she would be held to the same legal standards as a lawyer for the prosecution. And Vallow told the judge that she felt ready to handle her own case and that she had studied case law in both Idaho and Arizona in preparation for trial. And she has done a trial, let's not forget that, where she was found guilty of killing husband number 5's wife, Tammy Daybell, and also her 2 children. So she does have that in her favor, so to speak, although I think her attorneys didn't do the best job that I've ever seen representing somebody at trial. But hey, that's okay. That's okay. She is going to do it. Like I said, she's, according to her, she has participated in 3 full trials, referring to the 3 trials. Actually, it was one trial, as it related to the death of 3 people. She's practically a pro. A pro. Anyway, one of those trials was in Idaho, where obviously Lori Vallow was sentenced to life in prison without the possibility of parole for the murder of her 2 youngest children, Tylee Ryan, J.J. Vallow, and her 5th husband, first wife, Tammy Daybell. Now, Chad Daybell was also sentenced to death for the murders of his wife and J.J., and as well as Tylee, Lori Vallow's children. And Ms. Vallow is currently in Arizona waiting for that trial as it relates to the murder of her 4th husband. This woman is a black widow. Anyway, Charles Vallow is the issue at this particular trial, as well as the attempted murder of her niece's ex-husband, Brendan Boudreau. Now, the judge set Vallow's trial for March 31st and a status conference on January 10th. Note to Frank, put that on the calendar. It's going to be streamed, but I think this is something we need to go see for ourselves. We did it in Idaho. We got to go see it in Arizona. Anyway, the court-appointed attorneys who had represented her will remain on the case as standby counsel, which means if Lori Vallow is at any point comes to the conclusion that maybe this isn't the best idea, that maybe she shouldn't be doing this by herself, all she has to do is give the judge the secret nod, touch the finger to the nose, and standby counsel will come on. Now, obviously, it takes a little more than touching the nose with the secret signal to the judge, but you know what I'm saying. I've done this before. I was standby counsel on a court-appointed case years ago. The guy actually went pro se to the United States Supreme Court and won. He wanted to do his case by his own. He asked for standby counsel. I was like, well, what do you need me for? I've never won a Supreme Court. I hadn't then, but now I have. Anyway, and then he did his voir dire. He wanted to do his voir dire and literally said, hey, Judge, can Scott do it now? I remember I got called to the bench, and the judge said, Scott, are you ready for this? I said, well, Judge, I kind of had a feeling this may be coming down the pike. I said, but give me 5 minutes. I'll be ready to go. And I did my opening statements, whereupon a jury promptly convicted my client of doing various things that were not protected by the First Amendment. Okay? Once again, going back to how many podcasters out there actually try cases. Just saying. Just saying, ladies and gentlemen. Anyway, I'm feeling a little emboldened today just because I got 5 counts, not guilty, hour and a half, serious sex case. I'm tooting my own horn just a little bit. And I'm not going to lie, when I get done with this, I'm going to go down to the Brown Palace in Denver, Colorado, and I'm going to have a fine Cuban cigar. Okay, it's not Cuban. Well, maybe it is, but you'll never be able to tell because it'll be burnt by the time you get there. We're going to go turn some fine leaves into, burn them to dust, so to speak. Anyway, in a statement as it relates to the decision, Larry Woodcock, obviously Charles Vallow's brother-in-law and JJ's grandfather, who we've had on the show, and his lovely wife, put out a statement saying Lori thinks she is innocent. She murdered my grandson. She is nothing more than a convicted killer of children and a strong, intelligent Charles Vallow. What she did to our family and friends is nothing less than pure evil. Now, like I said, I must say, I love Larry Woodcock. I met him at CrimeTalk a couple years ago. They've been on our show. They were Patreon members, and they literally asked me for advice, like how things are. Like, hey, you need to contact this person. If you don't think they have a victim advocate, and you need to advocate for yourself and things like that. Anyway, I've spoken with him again last time I saw him. I love the man. He is just, a successful businessman. And I still swear to God, all right, that there would not have been justice in the Lori Vallow case in Idaho, but for the Woodcocks pushing and pressuring the authorities to keep the investigation going, because it easily could have been kicked to the curb. Somebody said, "Oh, missing children, put them on a milk carton or something." But the Woodcocks kept that going. So hats off to them. Obviously, we'll give Lori Vallow the presumption of innocence in her case in Arizona. But like I said, this is going to be a train wreck. I can't wait for it. I hope she testifies in her own defense. That's all we have for today, ladies and gentlemen. See you next week. Have a wonderful weekend. And remember, the Constitution matters.